Okay, imagine a scenario. You're standing on a sidewalk and you're watching a house just burn to the ground.
Right.
You can hear someone screaming inside. They're trapped by the flames.
Oh, wow. Okay.
So you do what anyone would do. You grab your phone, you call the fire department. But the operator, they stop you. They ask, is it your house?
Huh. No.
You say no. Then they ask, are you the one on fire? You say no. And then the operator says, sorry, I can't help you. Only the victim is allowed to make the call.
That sounds like a dystopian nightmare, or maybe something out of a Kafka novel where bureaucracy just completely trumps humanity.
It does. But for the longest time, that was, in effect, the logic of the legal system. It was this, rigid, closed loop. If you weren't the one bleeding, you couldn't ask for a bandage. But then something shifted. And it was a shift so radical that a single postcard, just a postcard scrawled by a total stranger, could trigger the highest court in the land to mobilize and, well, save thousands of lives.
It's not fiction. This is the story of how the Indian judiciary essentially hacked its own operating system to give a voice to the voiceless. We're talking about public interest litigation, or PIL, and honestly, it is arguably the most significant contribution the Indian judiciary has made to global jurisprudence.
Welcome to the deep dive. Today, we aren't just reading the rules, we are unraveling a legal revolution. But before we step into the courtroom, we have a very special welcome for our listeners joining us from the Simplified UPSC by PPP YouTube channel.
We're so glad to have you here. And just so you know, this isn't just a history lesson. This is like high-yield content for your syllabus.
Exactly. We are here to provide a full summary, and it's focused specifically on your UPSC preparation. We're going to be linking everything we talk about directly to past year questions, those all-important PYQs, so you know exactly how to use this ammo in the exam hall.
Because, studying this as just some legal trivia is useless. You have to understand it as a functional part of the Constitution.
Absolutely. And a quick call to action for our community here. We just have to humbly ask you to subscribe to the channel, and if you're capable, please consider joining the paid membership on YouTube to support the team.
Yeah, that support ensures we can keep bringing you this super useful content. It really does keep the lights on and the research going.
It really does. So a massive shout out to all of our existing members. You help us a lot in creating this content. Please don't forget to like this video and share your valuable comments. Also, an important notification before we get started. Free notes with practice PYQs are available on the Telegram channel. And for our legend YouTube members, premium notes with extra PYQs and model mains answers are waiting for you on the Discord channel. So do join there.
That Discord resource is, it's gold, especially for mains answer writing.
It is. Okay, now let's get down to business. Today we are opening Indian Polity by M. Laxmikanth, specifically Chapter 29. We are decoding public interest litigation. So let's start with the origin story. I think a lot of people, myself included for a while, assume this is a uniquely Indian invention because we hear about it so much here. Is that the case?
That's a really common misconception, but no. The DNA of PIL actually comes from the USA in the 1960s.
The 60s, wow.
Yeah. But you have to understand the context over there. It wasn't just some, clever legal maneuver. It was a response to a massive failure in the market.
The market of law.
Exactly. In the U.S., they realized that the marketplace of law was failing huge segments of the population. I'm talking about the poor, racial minorities, consumers, environmentalists. They were all being shut out.
Why? Just because they couldn't afford a lawyer?
Pretty much. They couldn't afford ordinary legal services. So PIL was designed to represent the unrepresented. It was about recognizing that if justice is a commodity that only the rich can buy, well, it isn't justice, is it?
Right. So it started as a way to help the underdog in America. But the Indian version, it feels different. It feels more, aggressive. How did it land here?
The Indian story is unique because of who brought it in and how they adapted it. It arrived in the early 1980s, and it was driven by two absolute titans of the Supreme Court, Justice V.R. Krishna Iyer and Justice P.N. Bhagwati. And they didn't just copy-paste the American model, that's the key thing. They looked at the socioeconomic reality of India, which was vastly different from the U.S., and they realized they needed to adapt the machinery of the court to fit the country, not the other way around.
I really want to establish the before and after for our listeners, because to understand why PIL is such a big deal, You have to understand just how restrictive the system was before it.
To understand that, you really have to grapple with a concept called locus standi.
Locus Standi. Okay, Latin. What does that mean in plain English?
It literally means place of standing. In traditional Anglo-Saxon jurisprudence, which is what we inherited, locus standi was incredibly strict.
How's it?
It meant that only the person whose rights were specifically infringed, the aggrieved party, could move the court.
So in your example earlier, if I punch you, you can sue me.
Right. If I punch you, you can sue me. If a stranger on the street sees it and gets upset, they cannot sue me on your behalf. They have no standing.
Which, I mean, that makes sense in a private dispute, right? You don't want random people interfering in personal fights. If I have a dispute with my landlord, I don't necessarily want my neighbor filing a lawsuit about it.
Ideally, yes. In a developed society where pretty much everyone is educated, aware of their rights, and has resources, that rule works just fine. But apply that logic to a country like India in the 1970s or 80s. You have millions of people who are illiterate, living in abject poverty, maybe even bonded laborers. They might not even know they have rights, let alone have the money or the know-how to hire a lawyer and walk into the Supreme Court.
So if the victim is silent because they are literally incapable of speaking up, and the law says only the victim can speak, then the injustice just continues forever.
Precisely. You were legally just a spectator to atrocity. That is the massive gap that PIL came in to fill. The Supreme Court essentially said, okay, we are relaxing this rule.
And how do they relax it?
They said that now any public-spirited citizen or any social organization can move the court to enforce the rights of others.
That's the critical unlock, isn't it? Others who are unable to approach the court themselves.
Yes, and that unable part is key. It's because of poverty, ignorance, or some kind of social disadvantage. It threw the doors of the Supreme Court open to the common person, allowing them to act on behalf of the most marginalized. It's no longer just about my rights, it's about our rights.
So if I see an injustice happening to a group of people who can't fight for themselves, I can step in. But does that change the nature of the courtroom battle? Because usually when we think of a court case, we think of a boxing match. You know, player A versus player B. May the best lawyer win.
That's the traditional adversarial system. One party tries to destroy the other party's argument. It's a zero-sum game. PIL is fundamentally different. It forces a shift from that adversarial model to a collaborative or investigative one.
Collaborative. That sounds strange for a lawsuit.
Yeah.
Who exactly is collaborating?
The petitioner, the state, and the court. In a PIL, the idea isn't to win against the government. The idea is that there is a systemic problem, say air pollution or prison overcrowding, and everyone is supposed to work together to find a solution.
Ah, I see.
The court stops being just a passive referee, and it starts being an active problem solver.
So the state shouldn't be thinking, how do I defeat this petitioner's case? They should be thinking, oh, you pointed out a hole in the ship. Great, let's work together to fix it.
Ideally, yes. That's the spirit of it. The courts have explicitly described it as a cooperative effort to vindicate the public interest. It is not a vehicle to settle personal scores. It's a vehicle to settle public issues.
The source, Laxmikanth. It mentions a specific mission for PIL. It outlines 3 core purposes. Let's break those down because this sounds like prime material for a mains answer on the philosophy of the Constitution.
Absolutely. This is pure GS2 gold. The first pillar is the vindication of the rule of law.
Okay, what does that mean practically?
It means ensuring that the law applies to everyone equally, not just to those who can afford to enforce it. If the law says no bonded labor, but bonded labor still exists because the victims can't sue their masters, then the rule of law is a lie. PIL makes it true.
Okay, that makes sense. It bridges the gap between the law as it's written in the book and the reality on the street.
The second pillar is facilitating effective access to justice. This is about removing barriers, not just financial, but also procedural, even psychological barriers for the weaker sections of society.
And the third one?
The meaningful realization of fundamental rights.
I really like that word meaningful there. It implies that rights can exist on paper, but be completely meaningless in reality.
Exactly. If you have a right to life under Article 21, but you're starving on the street because of government neglect, that right is theoretical. It's a cruel joke. PIL tries to make it actual, to make it real. The text uses a very powerful phrase here. It says, PIL brings justice to the low visibility area of humanity.
Low visibility area of humanity.
Wow, that hits hard. It's talking about the people society chooses not to see, the people we walk past every day.
And PIL forces the legal system to stop walking past them. It shines a powerful light into those dark corners. It says that the Constitution exists in the slums and in the remote villages, not just in the high-rises of the capital.
Okay, I want to play devil's advocate here for a second, because
Yeah.
this all sounds incredibly noble, but structurally, it sounds risky. If anyone can file a case for anything in the public interest, doesn't that just open the floodgates? Like, can I file a PIL because my neighbor is playing loud music and disturbing the peace of the whole neighborhood? Is that public interest? That is the classic fear that the Supreme Court becomes, the department of all complaints. But the answer is a firm no. You cannot just file a PIL for anything. The Supreme Court recognized this risk very early on.
So what did they do?
They established guidelines in 1988, which were then modified in 1993 and again in 2003, to specifically gatekeep what qualifies as a PIL and what doesn't.
So there's a checklist?
Effectively, yes, a sort of filter. Let's run through the yes list, the things the court has explicitly said, this is our territory. This is what PIL is for.
Look at that.
First on the list, bonded labor matters. This is the classic example. People trapped in labor cannot hire lawyers. They are the definition of voiceless.
Makes total sense.
Then you have neglected children.
Again, makes sense. Children don't have their own legal standing in most cases.
Correct. Then, non-payment of minimum wages or the exploitation of casual workers. This is huge because it addresses a massive economic power imbalance. You simply can't expect a daily wage laborer to sue a giant corporation.
No, it would be financial suicide for them. They'd probably starve before the first hearing even happens.
Exactly. Then there are petitions regarding prisons. Things like harassment, overcrowding, ensuring a speedy trial.
Right. I remember reading about cases where prisoners had been waiting for their trial for years, sometimes longer than the maximum sentence for the crime they were accused of. This is arguably one of the most successful areas of PIL.
That's a prime area, absolutely. The Husseinar Khatun case is a famous example, though the text just focuses on the category itself. Then there are petitions against the police for refusing to register cases.
Ah, so it's guarding the very gate to the justice system. If the police won't even let you in the door by filing an FIR, the PIL can kick that door open.
That's a perfect way to put it. And interestingly, the list also includes harassment of villagers by police or even co-villagers, specifically targeting scheduled castes, scheduled tribes, and other backward classes.
So it's heavily weighted towards protecting specific vulnerable communities. It's not just general public interest, it's very specifically margin-focused interest.
It is, very much so. And finally, the big one we see in the news all the time. Environmental pollution and protecting ecological balance.
Because who speaks for the trees? Or the rivers?
Or future generations, right. The public-spirited citizen does, through a PIL. The list also includes riot victims and family pensions. These are all areas where the public interest is substantial and the victims are often helpless.
Okay, so that's the yes list. Now, what about the no list? What gets rejected? Because I feel like a lot of people try to file PILs for things that really should be private lawsuits.
They do, all the time. The first big no is landlord-tenant matters.
Why not? I mean, a bad landlord could affect a whole building.
But it's still fundamentally a private dispute between two individuals over a contract. There isn't broader public interest involved in that specific legal sense. If your landlord is a jerk, that's your problem, not the nation's problem.
Fair enough. What else?
Service matters. Things like pension or gratuity issues for individuals. If you specifically didn't get your pension check, that's a tragedy for you. But it's not a PIL. You have to file a normal writ or a suit for that.
Unless it's a systemic issue affecting, say, thousands of retired soldiers.
Correct. If it's a systemic failure, it might qualify. But generally, individual service matters are out. Also, general complaints against central or state government departments don't qualify unless they fall into one of those yes list categories.
So the post office is slow. Isn't a valid PIL.
Exactly. And another big one here, admission to medical or educational institutions.
Right. You can't use a PIL just because you, or even a group of students, didn't get into the college you wanted. That's an administrative issue or a merit issue, not a fundamental rights crisis for the marginalized.
And finally, petitions just asking for early hearings in high courts, that's a no-go. You can't use PIL to cut the line.
So the system is designed to filter out private grievances that are sort of masquerading as public interest. It keeps the channel open for the true emergencies.
Correct. That's the whole idea behind the guidelines.
Now let's talk about the mechanics of it. When a court actually accepts a PIL, does it follow the exact same rigid rules as a normal trial? We talked about relaxing locus standi, but what about the process itself? Because if the procedure is still too complicated and expensive, the poor still lose.
This is where that cooperative nature we talked about really transforms the procedure. The quote relaxes the procedural laws significantly. You mentioned the postcard at the start.
I did.
That's a real thing. It's known as epistolary jurisdiction.
That's a fancy word.
It just means lettered jurisdiction. The court can treat a simple letter or even a telegram as a writ petition. No expensive filing fees, no complex legal formatting, no affidavits, at least not initially.
That lowers the barrier to entry to almost zero. You don't need a law degree or a fancy lawyer to just write a letter explaining a problem.
It completely removes that bureaucratic wall. Another key relaxation is the removal of what's called the maintainability defense.
Okay, let's decode that for the listeners. What does maintainability mean in plain English?
Usually, when you sue the government, their first line of defense, their lawyers will try to argue that the petition isn't maintainable.
How?
On technical grounds. Maybe you filed in the wrong court, or you missed a deadline by a day, or you didn't exhaust some other remedy first. It's a way to get the case thrown out without ever discussing the actual problem.
Right.
In a PIL, if there is a prima facie, which means an obvious, on the face of it, violation of the rights of a disadvantaged group, the government generally cannot hide behind these technicalities.
So they can't win on a technicality. They have to actually answer the substance of the accusation.
Yes. And perhaps most importantly, the court takes on an investigative power.
How so? What does that look like?
In a normal trial, the judge is a passive umpire. They sit back and say, okay, lawyers, show me the evidence. If you, the petitioner, can't find the evidence, you lose. End of story. But in a PIL, the court understands that the victims are poor and powerless. They can't go out and gather complex evidence, so the court itself acts. It can appoint commissions, sociologists, journalists, independent lawyers to go to the site, investigate the facts, and report back.
That is a massive shift. The court is effectively saying, we don't entirely trust that we're getting the full picture from the state, so we're going to go look for ourselves.
Precisely. It evens the playing field in a very profound way. However, there's a big caveat here. The court has to be careful. It generally will not transgress into the domain of policymaking.
Right, the separation of powers.
Exactly. That's the government's job. The line can get very thin and blurry sometimes, but the court tries very hard to stay on the side of enforcing existing rights, not creating brand new policy from scratch.
This sounds like an incredibly powerful tool. But, as the saying goes, power corrupts, or at the very least, power attracts people who want to misuse it. The source mentioned some pretty clever and cynical nicknames for when PIL goes wrong.
Oh, yes. Publicity Interest Litigation, or my personal favorite, Pizaz Interest Litigation.
Pizaz meaning money.
Exactly. And this is a major, major concern, and the judiciary is very aware of it. Pizaz interest litigation refers to people filing cases to extort money, maybe blackmailing a corporation by threatening a PIL to stop a big project unless they get a quiet payout.
And publicity interest litigation is pretty self-explanatory.
It is filing a sensational case just to get your name in the papers or get those 15 minutes of fame on the news channels.
So how does the Supreme Court stop this? It seems like opening the door to everyone also lets in the crazies and the greedy.
They've laid down very strict guidelines for themselves to prevent this kind of abuse. First, they explicitly state they must encourage genuine bona fide PILs, but strictly curb those filed for extraneous considerations.
How do they verify that, though? Do they, background check everyone who files?
In a way, yes. The first thing they do is check the credentials of the petitioner. Who are you? Why are you filing this? Do you have a track record of social work? Or do you have a hidden agenda? They have to ensure that substantial public interest is actually involved.
And they prioritize?
Yes, they prioritize petitions involving real gravity and urgency. They triage the cases to separate the genuine noise from the frivolous signal.
Okay.
And for the busybodies, that's the court's term for people wasting its time for personal gain or private motives, the court can impose exemplary costs.
Which is basically a heavy fine.
Very heavy fine. It's a powerful deterrent. It sends a clear message. Do not treat this court and this special procedure as a playground for your personal agenda. If you file a frivolous PIL, you will pay for it, literally.
That seems fair. You want the door to be open, but you definitely need a bouncer.
That is a very, very apt analogy. The court acts as the bouncer for its own jurisdiction.
Let's connect this all to the bigger picture for our UPSC listeners. The text links PIL directly to this other big concept, judicial activism. We hear this term thrown around a lot in the news, often with a negative spin. How does Laxmikanth define it in this context?
Well, PIL is described as the most popular form or the clearest manifestation of judicial activism. And Chapter 28 of the source text defines judicial activism as the proactive role of the judiciary in protecting the rights of citizens and promoting justice in the society.
Proactive.
Yes, it implies an assertive role, often forcing the other two organs of the state, the legislature and the executive, to actually do their duties.
So when the government is sleeping on the job, the judiciary comes in and wakes them up with a bucket of cold water.
That's one way to put it. The text actually describes it as the antithesis of judicial restraint. Restraint says judges should just stick to interpreting the law as written. Activism says judges need to look at the needs of society and ensure justice is done.
Okay, so looking at the past year questions, the PYQs that were provided in the sources, how does this fit into the exam? Because this is where the theoretical knowledge meets the practical marks.
This is where the rubber meets the road for our aspirants, absolutely. Let's look at the 2020 GS2 paper. There were questions in there regarding the separation of powers.
Right, the idea that the executive, the legislature, and the judiciary should all stay in their own lanes.
Exactly. And PIL often walks a very fine line between judicial intervention and executive function. When the court orders a commission to investigate pollution or prison conditions, critics will immediately argue that it's doing the executive's job.
So understanding PIL helps you write a much more nuanced answer about where that line is or should be drawn. You can't just write separation of powers is good. You have to explain the inherent tension.
Correct. You have to argue that while separation of powers is a key principle, so are checks and balances. And PIL is a powerful check. Then, if you look at the 2013 GS2 paper, that one had questions on inclusive growth and protecting vulnerable sections. It's specifically linked to the Companies Bill and Corporate Social Responsibility, or CSR.
How does that connect to PIL?
It's the philosophy. It's the same underlying principle. Just as CSR is about integrating the marginalized into the corporate framework, PIL is about integrating the marginalized into the legal framework. It's all about inclusion. If you're writing an answer about vulnerable sections, PIL is your go-to example of a state mechanism for their protection.
And there is a general theme in UPSC questions about the basic structure of the Constitution, right? That comes up a lot.
All the time. This references the famous Kesamanda Parati case that's mentioned in Chapter 28. Judicial review and the power to issue writs, that's under Article 32 and 226, are considered part of that basic structure.
So they can't be amended away.
Exactly. And PIL is essentially the mechanism that safeguards this basic structure for the poor and marginalized. If you were to somehow remove the concept of PIL, you would effectively be removing judicial review for the poor, which would violate the basic structure of the Constitution.
That is a very powerful argument to make in an answer. And we can't forget Article 39A.
Oh, that's a crucial point. Article 39A of the Directive Principles deals with free legal aid. And PIL is considered a strategic arm of the legal aid movement. It's the tool that fulfills the constitutional promise of equal justice that's found right there in Article 39A.
So when you quote Article 39A in an exam, you should always pair it with PIL as its practical application.
Always. It shows the examiner you don't just know the theory, you know how it works in practice. So you see, if you're writing an answer about social justice or separation of powers or judicial review, PIL is a concept you can weave into all of them. It's like a master key.
That's a great analogy. It connects the dots between these abstract constitutional articles and the reality on the ground for millions of people. Speaking of articles, let's get specific on the constitutional provisions that actually back PIL. We know lawyers love their articles. Which ones power this entire mechanism?
There are three main pillars here, constitutionally speaking. First and foremost is Article 32. This is the right to move the Supreme Court directly for the enforcement of fundamental rights. Dr. Ambedkar famously called it the heart and soul of the Constitution.
And that's for the Supreme Court. What about the high courts? Can they hear PILs too?
Yes, and that's under Article 226. It gives the high courts the power to issue writs. And interestingly, the high court's power under 226 is actually a little bit wider than the Supreme Court's under 32 because they can issue writs for other purposes beyond just fundamental rights. But that's probably a topic for another deep dive.
Okay, so we have 32 and 226, and the third pillar.
This one is the real game changer. It's Article 21, the right to life.
But isn't the right to life just, the right not to be killed by the state?
It used to be interpreted that way, but not anymore. And this is absolutely vital for understanding PIL's growth. The source specifically mentions the Maneka Gandhi case of 1978. This case was a watershed moment.
How so?
It fundamentally expanded the meaning of Article 21. The court ruled that the right to life doesn't just mean mere animal existence. It includes a right to live with human dignity, a right to a decent environment, and a right to livelihood.
Ah, I see where this is going. Once you define life as including a decent environment, suddenly you can file a PIL about industrial pollution.
Exactly. It expanded the canvas. Or if you define life as human dignity, you can file a PIL about the horrific conditions of bonded labor. This judicial expansion of Article 21 provided the fertile ground for PILs to grow and flourish. It gave the courts the substantive right that they needed to protect.
So before this case, life was just about biological survival. After this, life became about the quality of existence.
That's the perfect summary.
So, to unpack the implications of that expansion a bit more, when the court says right to life includes livelihood, does that mean the government now has to give everyone a job?
Not exactly, no. But it does mean the government cannot arbitrarily deprive someone of their livelihood without a fair procedure. For example, in the Olga Tellis case, it's also known as the pavement dwellers case mentioned in the source, the court ruled that you can't just bulldoze the homes of pavement dwellers overnight without giving them a chance to be heard, because their housing was directly linked to their livelihood in the city.
That is a perfect example of PIL in action. It connects the high-minded text of the Constitution to the guy sleeping on the pavement. It essentially says to that person, you matter to this document.
And that really is the essence of it, isn't it? It transforms the rule of law from some theoretical concept in a textbook into a practical reality for the poor and the ignorant. It ensures that legal poverty, not having money for a lawyer, doesn't automatically mean a denial of justice.
It effectively says that the Constitution belongs to everyone, not just to those who can afford the entry fee to the courtroom.
Correct. And if we look at the source material on judicial activism again, it mentions that this activist role of the judiciary often comes up when there's a legislative vacuum or a collapse of responsible government.
Meaning, when the politicians aren't doing their job, the judges are forced to step in.
Or when there's just a gap in the law that needs filling to meet changing social needs. The courts act to fill that void. A classic example is the Vishaka guidelines against sexual harassment in the workplace. That came out of a PIL because at the time there was no specific law on the books to address it.
So the court basically wrote the law because Parliament hadn't gotten around to it yet.
Exactly. That's a perfect example of PIL filling a legislative vacuum. But as we discussed with the Public Interest Litigation, it requires constant vigilance to ensure the judiciary doesn't become some sort of unelected super legislature.
It's a very delicate balance. The democracy fears that are mentioned in the text, is a profusion of PILs nurturing our democracy, or is it depleting its potential?
That is the million-dollar question, isn't it? If people start running to the court for every single problem, does it make our elected representatives lazy? Does it let the executive off the hook?
Why should we bother fixing the road? Let's just wait for the Supreme Court to order us to do it.
Exactly. These are the critical thinking points a UPSC aspirant needs to be pondering for their mains answers. PIL is a vital check, but it should not become a substitute for good governance. It's supposed to be emergency medicine, not a daily diet.
That is a fantastic point.
Wow.
We've covered the origins, the shift in Locus Standi, the core philosophy, the scope, the procedural flexibility, the potential for abuse, and the constitutional backing. It's a massive topic.
It is, but it's also one of the most logical ones. Once you understand the core intent to help the voiceless, all the rules and exceptions start to make perfect sense.
So to summarize it all, PIL is essentially the tool that takes the Constitution out of the library and the courtroom and puts it into the lives of the people who need its protection the most.
Correct. It ensures that the promise of the preamble justice, social, economic, and political, isn't just a promise on paper, but an actual delivery mechanism.
A truly fascinating deep dive into one of the most dynamic aspects of Indian polity. It really changes how you look at the news when you see a court intervening in a social issue. You realize it's not just activism in a vacuum. There's a structured constitutional mechanism behind it.
Absolutely. And for our exam-focused listeners, just remember to link every PIL example you read about in the newspaper back to Article 21, Article 32, Article 39A, and the concept of the basic structure. That is how you score top marks.
Solid advice. And that brings us to the end of this deep dive. Final reminder to all our listeners, this summary was tailored specifically for the Simplified UPSC by PPP community. We really hope this helps you connect the dots between Laxmikanth and the real world.
Keep reading those newspapers with this lens. It'll change how you see things.
If you found this useful, please subscribe to the channel and consider the paid membership to support these efforts. It really does allow us to keep going deeper and deeper into these topics for you. To our existing members, a heartfelt thank you for your support. Please like, comment, and share. Your engagement really helps the algorithm find other serious aspirants just like you.
It makes a huge difference.
And don't forget, free notes and practice PYQs are on our Telegram channel. Legend members, you can head over to Discord for your premium notes and those model mains answers. The links are all there for you. Keep learning, keep questioning, and we'll see you in the next deep dive.